Good afternoon and welcome to the Alternative Dispute Resolution Certification Working Group. And I want to remind you, as I just said, the meeting is being recorded. Ms. Marlaud, would you please take the roll?
Sure. Armstrong,
Here.
Coulter,
Here.
Curtis,
Here.
Dinkin, Dubow,
He's
Did
here.
I'll do-
He's here, Angela.
Okay, thank you, Diana.
you hear me?
I do now, thank you. Ellis,
Here.
Dr. Getz. Dr. Getz, I saw you, I
He's
think.
here. I see him.
Okay, thank you. Higuchi, Hodgson, Jones,
And then
Kelly,
Here.
Kopaken,
here.
Cruz,
Here.
Lowe,
Here.
Judge Lucky,
Here.
Palevsky,
Here.
Judge Pichon,
Here.
Robertson,
Here.
Tuckman, Eric Tuckman,
He's here.
I see him. He's here.
thank you. Welch.
Here.
And Yamshawn. Thank you.
Thank you, Ms. Marlaud. Next on the agenda is the call for public comment. State Bar staff will attempt to call members of the public in the order that they appear in the attendee pool. Ms. Marlaud, would you please provide the instructions?
Yes, for those participating by Zoom video, please use the raise hand function at this time if you'd like to give a public comment. If you're dialing in by phone, you can raise your hand by pressing the star key, then the number 9. We'll allow 3 minutes for each speaker and call on you in the order that your hands are raised. So if you'd like to give a public comment at this time, please use the raise hand function.
And
I don't see any raised hands.
All right, thank you. We'll move on now to the approval of the minutes from the last meeting. The last meeting was June 18, 2005. Are there any corrections or modifications to the open session meetings? I don't see any hands and hearing nothing. Ms. Marlaud, would you please call the roll?
Oh, yes. Can I get a motion first for the minutes?
Lucky, I'll move.
Thank you. And a second?
I'll second.
Was that Diana?
Yep.
Thank you. All right, I'll take the roll. Armstrong,
Yes.
Coulter,
Yes.
Curtis,
Yes.
Dinkin,
Yes.
Dubow,
Yes.
Ellis.
Yes.
Thank you. Dr. Getz, Dr. Getz. Higuchi,
Yes.
Hodgson, Jones,
Yes.
Kelly,
I'm afraid I'm going to have to abstain because I missed seeing those agenda items, but minutes, but I believe everybody else.
Kopaken.
I also missed those, so I too will abstain, but
Okay.
thank you.
Cruz,
Ironically, I'm in the same boat as Ron, so I'm gonna abstain too.
thank you. Lowe,
Yes.
Judge Lucky,
Yes.
Palevsky,
I'll approve them, but I don't remember seeing them either. So maybe there's confusion as to what constitutes the minutes.
Robertson,
Yes.
Tuckman. Thank you. Tuckman,
Yes, although I'm in the same boat as well. I'll see them.
Welch,
Yes, I saw him on the website.
Yamshawn,
Another abstention.
Madam Chair,
and
can I raise a point of order?
Yes.
Given that there are at least 5 of us who somehow did not see the minutes, I wonder if it would be appropriate to postpone this to the next meeting. I'll take the chair's advice on that.
What we can do is after Ms. Marlaud finishes calling the roll, I can see if there's a quorum and it will pass, but I'm sure you would like to be informed without me doing that. So we can just move the minutes, approval of the minutes to later, and we'll take a break uh, at the appropriate time, and then the members can read the minutes. But let me ask Ms. Marlott, is it possible to send everybody the minutes during the meeting?
Yes, I can do that.
Okay, so the minutes will be sent to everybody, and if you like, we can just do another recall of approval or not later on in the meeting, and I'll just make a note to come back to it.
Thank you, Madam Chair. I appreciate that.
Okay, great. Okay, so Ms. Marlott, we'll just dispense now with the roll call and just hope I don't forget to go back to the minutes. So I will make a note to myself to do that.
Okay.
All right, thank you. So now we'll move to the chair's report. That's next on the agenda. I do not have a report per se, but there are a few comments that I would like to make to our illustrious group. And they are that, today I want to make sure we understand what we'd like to do. We will discuss again the recommendations of the two remaining subgroups. Each subgroup has examined the issues in great depth, and I'm sure those of you who are on the two subgroups realize that. The subgroups have also discussed the additional questions that were raised at our last meeting. So at this point, there's no need to send matters back to the subgroups for more discussion because the groundwork has been laid. Our goal this afternoon is to allow our recommendations to move forward to the first round of public comment. And I'm going to stress the words first round. The decisions that we make today are not about final approval. It's simply to move our recommendations forward and out of the working group. This is an essential step in this process because it will give our stakeholders and the public the opportunity to share their views, raise new issues, and test our thinking and to assist us in producing the best product. Please understand that the working group will carefully review every public comment received, and we will still have the opportunity to make revisions before making any final recommendations to the State Bar Board of Trustees. Nothing that we do today is being set in stone. And I know that you all understand that it is the legislature that determined that there must be a program to certify alternative dispute resolution firms, providers, and practitioners. Some of us supported the idea and some of us opposed it, but it is now the law. And it is our responsibility to make recommendations to the state bar on how to implement it. And we agreed to do this. While the statute may not be perfect, as we've come to learn, it is the framework that we will and must work with. And you, the working group, you are the select group of leaders and experts who are chosen to guide this effort. You have devoted yourselves with energy, knowledge, and candor, and your contributions have been invaluable in shaping these recommendations. So now it's time to let others join in on our conversation. This is our opportunity to open the doors, to invite feedback, and to hear the perspective of others who will be affected. We should expect many comments that differ from our own thinking and even brand new concept that we have not yet considered. That is the nature of this process, and it is what will make our final product even stronger. This is our mission should we decide to accept it. So now we'll move on to the staff report. Mia Allen, does the staff wish to make a report, or do you have anything to report at this time?
I don't have anything, Judge Pichon. Alan?
Just to emphasize what Judge Pichon has said, and also to mention that I was hearing some feedback, so I have muted everyone. If you wish to say something, just please note that you're muted.
Okay, thank you, Mia and Alan. So now we'll go on to the business portion of the meeting. And that's item 2.1, and it's an update and action on recommendations from the baseline certification and recertification requirements for mediators. The lead is Dana Curtis. And Ms. Curtis, would you please proceed?
Yes, thank you, Judge Pichon, and good afternoon, everyone. I want to start, as I always do, by thanking our amazing subgroup members who brought their broad experience and their thoughtful analysis and scores of hours to develop the baseline qualification for mediators recommendations. We've gone through them several times, and I want to also thank Alan and Mia for all of the effort that they put forth to help us prepare and to present and then to follow up. And Alan, particularly for the your memo that everyone received on the 15th of August. It was very thorough. So what I will be doing is repeating some of that in sort of summary form, but if you are interested and haven't had a chance to read it, it really does describe our process very thoroughly. Excuse me. So today we're going to present once again the recommendations that we've presented. We presented in the last meeting and that you've had an opportunity to review for several months actually now. We went through this together in some detail and the baseline qualifications in some detail and listened to your questions, concerns, your comments, went back to work, spent another 4 hours reviewing and responding. And so essentially what I will be doing is presenting the new portion, the new definitions, which are really two parts: qualifying mediations, and we've gone back and heard you about how you wanted much more definition and understanding about what constitutes the beginning and the end and so forth. And then there were quite a few questions concerning the reflective practice groups requirement, which was a new requirement, as you recall. And you really looked for a clearer definition of what those were. You had concerns about confidentiality and that might be breached in the process of these back and forth conversations about cases, and also wondered about how to go about documenting your participation in those for the purposes of recertification or for application. There was a question about the mechanics of reporting when you do fulfill the requirements, and we won't be addressing that today. We have decided that that's much more appropriately handled by the subgroup in the future on administrative procedures. So Alan, if you could please bring up the attachment 3, that would be very helpful. Thank you. Thank you very much. So I wasn't planning on reading through these. I think we've done that maybe 2 or 3 times, well, at least 2 times, and quite thoroughly in the last session. So if anybody believes it would be helpful to do so, let me know. Otherwise, we'll move on and just talk about the new portions, the new definitions that we've supplied so that you can understand what they are and what our thinking was. And I'm not able to see hands of everyone. So Angela, you might be monitoring that. And do you see any hands of anyone who wants us? Yes, Paul? Paul, you're muted. Paul?
Okay, one of the requirements for a qualified mediation is that the qualified mediation, in order for a mediation to be qualified, it has to have a joint session.
So can I stop you for a moment?
Sure,
The
sure.
question presented now, and I want and invite you to bring that up in a little while, but the question now is whether we need to go back through the
Okay,
qualifications for training
okay, so you would want to do that later.
yeah, that's later.
Okay,
Okay, Ron, and that's true for you too? Okay, good. Anybody who wants us to review, Paul, could you put your hand down, please? And then
Oh, I'm
anybody?
sorry.
That's
I got
okay. It's hard to keep track of everything. Okay, so seeing no other hands, then I'll just move on and we'll present what we created in response to your concerns. So Alan, thank you so much for highlighting the parts that have been changed in yellow and helping us to be able to focus on that. So qualifying mediation, and it's just for the purpose of certification. We're not trying to define mediation in any broad sense of the word, but it's just for the purpose of, for our purposes here, is it includes at least 2 hours of mediator facilitation in one or multiple sessions, beginning when the mediator agrees to mediate the dispute and ending when the mediator or all parties state that the mediation has ended. So let's just take that one. We'll take these one at a time. And you know, the way that we defined it was that a mediation needs to be a total of 2 hours. It can be in one session or multiple sessions. That 2 hours can accumulate. It begins when the mediator agrees to mediate the dispute and ends when the mediator or all parties state that the mediation has ended. Any questions or concerns about that particular part of the definition?
Yes.
Just that number one.
Okay.
Okay.
I have my hand up, I think.
Yeah, I think you have your hand up for number 3.
Okay.
That's okay. I'll
No,
remember.
I have a question about mediator facilitation. It's not defined, and maybe it does need to be defined. My question is, would that include the case where a mediator is assigned a case, briefs come in prior to the session, the mediator then calls the participants and tries to settle a case on the phone, so to speak, and sometimes the mediator is successful doing that. Is that a qualified mediation?
Well, it might qualify for the first part. That is that, you know, that it might be 2 hours where the mediator has been facilitating. It also might, and it might also be, you know, the mediators agreed. But then when we follow with the next one, allows the mediator to observe or otherwise communicate with participants in real time. So
would that include, the mediator has to read the briefs? It could take anywhere, it depends on the size of the brief, obviously, or how much time it takes. And the mediator may have to do some research, I don't know. But what I'm concerned about is a case where you get a mediation and you settle it beforehand or before the session because you're able to convince the parties to settle in phone conversations, and the total may not reach 2 hours, but it has been a very effective process. And let's say, just for argument's sake, there's a mediator out there who is so good that he or she always settles beforehand. That mediator could never be certified if those conversations are less than 2 hours.
Okay, so thanks, Paul, because it gives us an opportunity to clarify some of that. This came up last time, and we talked at at length. I'm saying an hour or more, or maybe two, I don't know, about this definition. And so what we're not saying that every mediation should include all of these things. It's just that these are the activities, I guess is a better way of saying it, that we believe that the reasonable consumer would be able to expect from a mediator. So, in some some ADR parlance, what you're describing is more of a conciliation process. So we won't get into the whole detail about definitions, but what we're really looking for is something within these qualifying mediations that can ensure that a mediator has the ability to work with parties in these particular functions. And that goes to including a joint session, which we realize is rare in these days, but that parties that we believe that mediation includes the ability to be able to help people manage conversations face to face. So you may have 20 mediations that you settle before the case, that you settle before anybody, you talk to anybody in real time, or you are in a joint session. But it means that if you wish to qualify, you'll need to do the minimum number that include these particular characteristics.
Okay, but how do I know that, Dana? For example, in my own case, the majority of my mediations involve employment disputes. Normally, the parties do not like each other, more so perhaps than the average case. And they rarely want to have joint sessions with them. They usually are not helpful. So I would say in the majority of my employment mediations, I don't do a joint session. So what you're saying is it's okay as long as I demonstrate in some fashion that I can handle a joint session? And if so, how do I do that?
Well, you do it by conducting one. So, you asked, how do I do it? And, in my own practice, I have the first session, whether it's video or in person. It may be very short in joint session so that people can introduce themselves to one another
Okay.
and talk about how we're going to proceed throughout the day.
Okay. So that would be a joint session. I never thought of that as joint sessions. I meet with them jointly for the beginning of the mediation. I always tell them something about my background. I explain confidentiality to the parties, and I often try to give a spiel how bad trial is and how better mediation is.
We all do different things in that session, but
that would be a joint session.
yeah, I mean, it demonstrates that you're capable of
That's
being
fine.
in a room with the parties all together and having it, however limited or extended, having it be something that they can be comfortable with and benefit from in our view. So, yeah, does that answer your question, Paul?
Yes, it does. Thank you, Dana.
Thank you. You're welcome. Yeah, and I see Daniel.
Thank you. This is kind of a variation on Paul's question. In those kinds of cases where the parties really can't stand to be in the same room, I just, as a matter of practice, always have pre-mediation phone calls with counsel. And we go over the process and explain the process that I use because each mediator approaches things a little bit differently. Now, would that count as a joint session, even though the parties are not present during that phone call, only opposing counsel are there?
I'm inviting anybody else, by the way, in the subgroup to chime in if they disagree with me or they'd like to take on the question, and I forgot to say so. But in our view, these are pre-mediation calls are very important, and we understand that. But did not see this as part of the 2 hour that counts, that just as we didn't see other preparation as the 2 hours that count toward the mediation session itself.
Thank you.
Yes, you're welcome. Diana.
Just on the joint session piece, I think most people interpret that as meaning everybody's in the same room with each other, Dana. And I was wondering maybe if we click on that too, you've got a more expansive definition. But certainly we can all imagine cases, and I think a lot of us have been involved in cases, right? For example, I just mediated a sexual assault dispute, right? A few weeks ago where not only would you not want to put them in the same room, but it would be contrary to the purposes of mediation to put them anywhere near each other. And as someone who used to preside over the restraining order calendar, one of my favorite neutrals who would come in and volunteer her time to mediate cases also de facto never put people in the same room together unless she thought it would be cathartic, beneficial, and advance settlement discussions. And I would hate to exclude neutrals like her, who does, I think she does solely restraining order mediations, if she was confused on what the definition of joint session was. So assuming a lady like her who's done hundreds of mediations, but perhaps never actually put people in the same room. Would she meet this?
Well, thank you. We didn't talk about that sector of practice, which, you know, and where it's commonplace to not to have a joint session. So I think that's something that we could think about together, and perhaps you could propose something before we vote that might help with this, since we're looking to vote on these today. So if you're willing to do that, just perhaps come back and we can do that. Would you be willing to think about that a little bit further in real time today, Diana? Because that
Yeah,
would
for sure. I just like maybe
Yeah.
the definition of joint session. I don't know where that two goes, and I'm so sorry. I looked at the recommendation, but maybe there's a definition that
Oh, it clicks back to the the table above.
oh, I see.
Yeah, it's a reference to how it's the definition of, anyway, yeah.
Yeah,
But I
listen,
wanted
I think my suggestion, Dana, actually to the group is to eliminate that requirement, frankly, because I could think of a lot of cases where it's not appropriate, and I could think of a lot of cases where it is. But I remember Ron in all of his wisdom once telling me, like we can't exclude family cases because, sometimes it can be beneficial to have a joint session. And so I'm not sure I would want to parse it out. I think the right result might be to eliminate three because there are certain classes of mediators who might not want to do a joint session, and there are certain classes and cases where they might want to, but to kind of give mediators the flexibility when appropriate and perhaps in a limited fashion to do so in their discretion. I would just hate to exclude fantastic people like the woman I was talking about, who is very qualified, I think, but who may not have ever put people in the same room together.
Thank you so much. No, we wouldn't, our effort, anyway, we didn't want to exclude, but hadn't considered that particular aspect. Thank you. Nolan.
Yeah, I think continuing on Diana's point, particularly in the commercial mediation space, people who are mediating tort claims. I think overwhelmingly the practice is not to hold joint sessions, and that's been the case now for really as long as I can remember, at least the last 10 or 15 years. I'm sure there's still some people who do it, but I think the great majority of mediators don't do it. And sort of looking at the likely demographics of mediators who we would hope to have certified, it seems like the greatest number are likely to come from that sort of commercial mediation space. So I think that having this requirement is potentially going to dissuade a lot of people from becoming certified. So I'd also be in favor of just removing it.
Okay, thank you, Nolan. Katie?
I think I'm going to end up with somewhat of a similar comment to Nolan, but I would like to just note that my perspective is as a case administrator. I work with at least 25 of the ADR Services Inc. panelists directly managing their calendars. And I cannot tell you how many times I've been specifically contacted by counsel to request that there is not a joint session convened. So the strong movement has been away from doing those. Of course, I acknowledge that in many circumstances it could be useful. But I have a broad swath of panelists on my register, including trust and estate work, family law, intellectual property, employment, medical malpractice, personal injury. And that seems to be the common trend across the board, that folks have moved away from the joint session requirement or even interest or willingness to try it.
Okay, thank you, Katie. Jill?
Okay, thank you, Dana. First of all, when we met in subcommittee, I actually think I articulated this position because I thought it was an important one that would be discussed. And so we actually did have some pretty robust discussion about most of the topics, although the very particular case that Diana raised, I think we didn't talk about somebody who was exclusively doing things like, harassment and restraining order cases. Those are obviously a very unique situation. We did not drill down to that particular unique situation, but we did have some pretty robust discussions about commercial cases and IP cases, of which I handle and many of others who we talked about handled, as well as family law cases, which folks in our subgroup have handled as well. And what we circled around to was that we are certainly not proposing to define mediation as something that requires to have a joint session. But if you do not have the but the certification requirement implies a certain level of competence. And so we felt like it was reasonable to at least discuss and have public comment about whether we needed to have that as part of a qualifying mediation to demonstrate competence in real practice. If people have never done a mediation with a joint session, then are we comfortable qualifying them as, certified mediators? And remember, we're only, there are a limited number of these that have to happen as qualifying mediations. It doesn't mean you have to impose a joint session in any case that is extremely, where it would be inappropriate to do so. It just means that you have to have had a case, or the correct number of cases that would qualify you. So, I think we did discuss that. And yes, the trend is away from doing, the old school of parties, getting up and making presentations, but most people are capable of having some kind of a joint session. And so we thought this was an in-between. So I'll leave it at that. I just don't want to remind you that we're not talking about definition of mediation. We're talking about qualifying mediation for the purposes of demonstrating that you have a certain level of competence in order to be certified.
Thank you, Jill. And Ron?
Thank you. Well, I wanted to speak forcefully in favor of this requirement. I have found in 30 years of mediating in a very diverse mix of cases, including separating couples with a shared home and children, probate cases with sibling heirs, partnership dissolutions, CEOs of businesses trying to figure out how to go forward. We have complex interrelations, neighborhoods fighting with municipal governments, that joint sessions, if you know how to conduct them well, really improve the possible quality of a settlement beyond just party A and party B separate and party B pays this much money. And there's a whole lot of cases that The lawyers really are uncomfortable. They can't imagine what a joint session would do. And that's because they've not been in a joint session that's been facilitated by somebody who really understands how to restructure a difficult conversation between the principals. I want to speak very forcefully in favor of this staying in there. And when we get to it, whenever it's appropriate, if we're going to require this, and I don't know how the ultimate vote's going to turn out, but then I'd like to see this item added as a requirement of the trainings, because if we're going to require it, trainings ought to cover it. That's all I have to say. Thank you.
Okay, thank you, Ron. And Eric. Eric?
Yes, can you hear me?
I can.
Great. I would add the AAA also internally of the comments to the various standards, drafts that were sent around. The idea of the joint session really did get a very strong, I'll say, negative reaction, just because, at least in our experience, it's very common that joint sessions aren't part of the mediations we're administering. And that's across very, different types of cases, but admittedly it doesn't involve things like family matters or things that can be more contentious, but certainly does include employment. Jill's explanation actually was very, very helpful. I'm sure there was a reason that the joint session was included in the qualifications criteria. And I understand that capability, if they're going to be certified, at least having that capability, whether it's used regularly or not, needs to be something that is a skill for mediators going to be certified. I'm wondering, though, actually also thinking about Ron's comment, I was going to suggest, again, support for removing it. One possibility, though, is if we feel as though this is an important skill, is actually to add it to the qualifications or the training requirements, but we could still remove it. If there's some requirement that would at least provide certified mediators with exposure to this concept at the very least. But there's an implicit, I think, assumption if it's included here, even though it's not, it's part of the certification requirement, it reads as almost an implicit endorsement or need to have joint sessions in most mediations. Dana, I can't hear you. Dana? I think you're on mute.
All right, there are barking dogs in my background today. Okay. I'm in Idaho.
You're lucky.
Yeah, I am. Anyway, yeah, that it's following on what Jill had to say, that emphasizing of this in this way may mislead people, mediators, into thinking that it's an endorsement of this particular approach in every case. And so we need to think about how to include it. And thank you for the alternative that you presented as well.
I'm sorry, I have one other quick procedural question about the comments. I meant to raise this. When these are sent out for comment, is there a possibility to have items like bracketed language or footnote a question about whether a particular issue should be included or not?
I'll answer for that, Ms. Curtis. Yes, Mr. Tuckman, it can be singled out to ask for public comment on that specific issue.
Thank you.
Thank you, Judge Pichon. Paul? Paul? Oh, I think he just put his hand down.
Okay. Here's my suggestion. Dana's answer satisfied me, but I'm here. If I was not a member of the working group and I was doing employment mediation where there are very few joint sessions as we think of them, what we think a joint session is, I probably would not apply for certification in the erroneous belief that I'm ineligible because I don't do the traditional joint session. And perhaps either as a footnote, as Eric suggested, or in the body of the document, you state that joint sessions not only include explanations by the mediator about how mediation works, confidentiality, etc., so that a person who does not do the traditional joint session would understand that he or she is eligible for certification.
Okay, thank you. So something like includes a joint session of any length, including the initial session, and I'm sort of getting
just
a
a language,
thing that
just
more clearly defines it and
Yeah.
makes
Yes.
it. Yeah. Okay. Thank you. And Steve.
Yes, I agree with the vast majority of comments today that I feel that the inclusion of the joint session doesn't reflect the modern day practice of the vast majority of professional mediators. And if the purpose of this exercise is to demonstrate either competence or to instill confidence in the consumer, if we broaden the definition of a joint session to just the introductions and the mention of confidentiality, that's not truly demonstrating competence. You'd have to go to the point where you're, facilitating a true, discussion, a mediation. So just having people in a room and introducing and defining mediation and talking about confidentiality, that doesn't, if you include that as a joint session, it makes it somewhat irrelevant anyway, in my mind. So I do agree with the vast majority for the purposes of this that we shouldn't include the joint session as part of this, but I think people should be exposed to that in the training. And that would be a good compromise to addressing this issue.
Thank you, Steve. And Katie.
Thank you, Dana. I had one more comment. I would just like to strongly encourage consideration of Mr. Tuckman's recommendation to move the qualification to the training items. I agree that it doesn't really fall within the same purview as the other items. It's more similar to like a tool that mediators can use and if they're going to demonstrate competency of one tool, why wouldn't you include mediators' proposals in the requirements, like how to issue brackets? It's more of a training item, I think. And overall, our responsibility is to come out with a program that's going to be self-supported as well, and that truly is an adverse reaction to this joint session requirement among mediators that I think would strongly dissuade many potential applicants from pursuing certification, thereby undercutting our market and potentially resulting in an unsustainable program in the long run. So that's just my concern there.
Okay, thank you. And Dr. Getz.
Thank you, Dana. Can you hear me?
Yes.
Okay, fantastic. Well, I'll play mediator and say, we had a lot of great comments and you're all right. But I sort of think the points that Katie and Eric made, while I agree totally with Ron that joint session is such a valuable part when it's used, but I agree with moving it to the training aspect and not part of the mediation. And the main reason for that is mediation is about the voluntary agreement of the parties. So if the parties decide that they don't want to have joint session, that's what mediation is. It's not us substituting our judgment about what's valuable for them as part of it. So I would say most certification initiatives nationwide do not speak to the form or style of mediation. And this unfortunately does, even though it's well intended. And the way you know that is because if you thought caucus was a good skill, if you substitute caucus for joint, we'd have a lot of people saying, well, wait a second, there's a lot of mediations that don't involve caucus. So, it does unfortunately present a bit of a bias on our part for the transformative facilitative. And usually the state stays away from that, and most certification initiatives stay away from that. But again, important skill to require in the training. And so wholeheartedly agree with those of you who suggested that. Thank you.
Thank you, Dr. Getz. And Judge Pichon, just as a point of order, it sounds like it might be appropriate to amend this number 3, or excuse me, to eliminate there are a number of people who believe it would be important to eliminate it, and then also to include it in the description of the things that must be contained within a 40-hour training. And I'm just wondering if that would be appropriate to do right at this point.
Yes. Yes, and I'm glad you asked that. And it is. And so you're free to make that motion.
All right, I'll move.
So-
Or should somebody else move? I don't, sorry.
Ms. Curtis, I didn't say that right. So yes, you can make the motion to take the joint session out and put it in training. And then if there are no more questions, or if you don't have any more discussion about the recommendations from your group, then we can include that in one whole motion about the recommendations from the subgroup.
Okay, great. So I move that we eliminate number 3 and include a requirement that facilitating joint sessions be added to the description of the requirements for mediation training, 40-hour mediation training.
Point of order,
Mhm.
Dana.
Mhm.
You're combining two different things in a motion. I would really appreciate if you could separate that.
Sounds good.
Okay.
Okay, eliminate number 3. I move that we eliminate number 3.
So let me just ask staff, either Ms. Ellis or Mr. Weiner. I don't know if Ms. Curtis has finished her discussion regarding everything else, all the other recommendations of the subgroup. Is it appropriate for us to take a vote now rather than wait until the end of her presentation?
Yeah, if I may, Judge Pichon, I think that Ms. Curtis has not finished her presentation.
Yeah.
Has more to talk about, and maybe we can just make changes as we go along, and then possibly have one vote, as I think you're suggesting, on the recommendation as amended. And I'm showing this, hopefully you can see it in red strikeout, because that seems to be the direction that we're discussing.
All right, very good. Now I see 2 more hands, and we're almost out of time for the discussion from this subgroup. So I'm going to ask that we be very brief if it's still related to the joint session. So I'm going to turn it back over to you, Ms. Curtis, and I see 2 hands.
I would ask that you think about whether this is something new or an endorsement, and if it's not new that hasn't been said, that you not say it again. Otherwise, happy to hear something new. Daniel.
Yeah, basically, please clarify, is this vote over the entire proposal as with the redaction of number 3, or are we just voting on eliminating number 3? Because I have some questions about attachment 1 that we just kind of skipped right over.
Mr. Weiner, and I was just going to say, we are not voting on anything right now. We're going to allow Ms. Curtis to finish her presentation. And Mr. Weiner has highlighted it with a strikeout. So we know that that's going to be part of the motion. Mr. Weiner?
I was just going to say that. Thank you, Judge Pichon.
Okay.
Okay, thank you.
Thank you.
And Jill.
Yeah, just briefly, just a reminder, I have a pre-existing commitment at 3:30, so I may not be around to vote. I hope I will. I don't, and procedurally, if we're voting on the whole thing, it might be that some folks would vote yes on one portion and no on other portions. So I'll leave that to when you get there. But since you were talking about the process, I just wanted to raise those briefly. Thank you.
Okay, thank you so much. All right, we'll come back to this after I finish the next part of our discussion, which is qualifying peer feedback and reflective practice activities. So if you could scroll down, Ellen, that would be helpful.
I'm in the wrong document. Give me just a moment, please.
So as he's doing this, I'll just remind you that our effort was really to define these processes and address some of your concerns about confidentiality and documentation.
Are you seeing the correct document with me in the
let's see.
that section you want to discuss? Does that come up?
Not yet.
Okay, let me just maybe stop sharing and start a new share. See if we do better that way.
Okay. And while he's finding that, and I ask that we keep our comments brief, and if it's been said, keep it even briefer. But I agree with Ron, or if that's even necessary. But just so that we can make sure that we accomplish our intended.
Are you now seeing the document that you're hoping to be seeing? With includes a joint session.
No, it says 2 of 3. Can we go down to page 3? There.
Yes, but it starts at the very bottom. Let me just.
Okay, I see. Okay, so thank you. All right. So qualifying peer feedback and reflective practice activities are interactive. So what we did is we pulled out the qualities of these sessions that are really quite different from a lot of mediation training or training or teaching or CLEs and so forth. But it's interactive. It can be one-on-one private meetings or structured small group interactive meetings in which mediators explore in depth their mediation experiences, exchange constructive feedback, and share perspectives on ethical, personal, and practical challenges, as well as problem-solving strategies and creative approaches. Small group practice groups may be peer-led or facilitated by an experienced trainer. Lectures or presentations that do not consist of participant interaction by presenting cases or providing feedback do not qualify. The next one, qualifying peer discussions are one-to-one sessions with another mediator in which a certified mediator discusses mediation experiences and receives or provides feedback. Observation of a mediation also qualifies if the certified mediator receives or provides feedback. Confidentiality and certified mediators must maintain confidentiality in peer discussions and reflective practice sessions by eliminating or altering mediation participants' names and any other details that might lead to identification of the participants or the dispute. And the last one, record keeping. Certified mediators must contemporaneously record the dates and the names of the session facilitator or colleague, the number of hours spent in each session, and maintain this information and provide the information to the State Bar on request. So that is it. Any comments, questions? Okay, good. Katie.
Hey, thank you. I wanted to just clarify the you have the term certified mediator in here a few times So is it referring to like recertification, or is the expectation that somebody seeking certification needs to find a certified mediator to have these conversations with? Can they have them with any mediator? Like, just could you clarify that, please?
Yeah, they could have them with any mediator. It could be a group with some who are certified. If you're applying, nobody's certified. So, the answer is it's flexible. I think the term was just intended to clarify that the person seeking recertification or certification is the one who's actually participating. Thank you.
Understood. Thank you.
Did that do it? Yeah. All right, Diana.
Hey, just wanted to reiterate my objection to including this in the certification requirements. And I won't belabor all the points I made at the last meeting, but just briefly say that even with your confidentiality definition, which I think is a very helpful addition, that I think that there's going to be a lot of negative unintended consequences of this in terms of people being encouraged, frankly, to breach confidentiality and engage in these discussions. I think that there's little value to including this in terms of certification. And speaking of discouraging people to be certified, when we discussed it in the CLA, a lot of the members of that board had a highly negative reaction to including this piece as well. So just remember the last comments that I made, because there's other reasons why I don't think it's beneficial, but I won't reiterate them to save time. Thanks so much, team.
Thank you. Paul. You're muted. Paul, you're muted. Paul, you're muted.
Angela, can you unmute him?
Okay. Okay. Am I okay now?
Mm-hmm.
All right.
Yes.
Thanks, Dana. Yeah, I agree with Diana that this is unnecessary. Here's why I'm concerned. I don't think putting not identifying the mediation or using a false name is going to avoids breach of confidentiality. If I talk about what happened on a mediation, I'm breaching confidentiality whether I mention the name of the participants or don't. So going to a withholding of names will not help the situation to begin with. Secondly, I would suspect that if a mediator wants to talk about a case, he or she wants to talk about a case where the mediator felt that he or she had not done the best job possible. In other words, perhaps failed to settle a mediation. So most mediators, can settle 80 to 90% of their mediations. So it won't take a rocket scientist for a third party to figure out what case you're talking about if that party has some familiarity with that case. And it also puts the mediator with whom I speak in a bad situation. I tell him or her about the case, don't mention names, and that person may go to a third person and talk about the issue and mention that I had this problem. And that third person, unbeknownst to the second mediator, may have been a participant in the mediation. And that would be very embarrassing, I think, to the first mediator. So that's another problem. I agree with the intent of the subgroup that it's a good idea for us to increase to better our skills. And if I fail to settle a case, I'd be interested to know what I could have done better and then therefore settled it. And I think this could be accomplished again in training, where you go where people will talk about their mistakes in mediation and in a general manner and have a general conversation it's less likely that that will become known to the parties, and it probably may not be, I'm not sure, but may not be a breach of confidentiality.
So I'd like to respond to this very quickly, especially this last point. I do think it happens that we do consult with peers, and that you know, so that and that it is very helpful. This is just endorsing it, I guess, or actually requiring that level of reflection. I understand the concern about confidentiality as to third parties who are not in the practice group itself or part of that discussion. And that actually is a ground rule for these groups, and we just failed to include it. The other thing is that the Northern District has run these groups for, I don't know, 15 years monthly. And there are times when they have required them of their panels of mediators. So there's a lot of history here that, and I've conducted many too. So it takes very little specific information, since mediators are talking about their own participation in their own activities, just to clarify if there's a way to make it more, make it clear about confidentiality. And Diana.
Yeah, just one final thought for the group's consideration, and I'm putting my Cliff consumer protection hat on here. If I'm just a, plain Jane off the street, if you told me that there's mediation confidentiality, but your neutral might talk about your case with, 6 of her friends later, I would be horrified and I would not want to engage in a mediation. And I'm trying to put myself in a non-lawyer's, non-ADR person's perspective. I mean, my guess is that would hit a lot of people the same way on the street.
Okay, thank you, Diana. And I don't see any more hands. Anybody else?
Apologies for not having hand up. This is Jenna Ellis. I just wanted to suggest that, given this has been a more divisive portion of the subgroup's recommendation, that when it does come time for a vote, there could be value, as Jill suggested, in perhaps moving this component to a separate vote. I'll just add, for my piece, in addition to some of the concerns already raised, I truly believe in the value of personal reflective practice, but I would hate for folks to be required to do it, and for some, for it to then become a box checking exercise and not be something that is meaningful. And in some ways, I think by requiring it in this fashion, it could lose its meaning and value. So just a kind of unusual thought on that. Thank you.
Okay, thank you, Jenna. Dr. Getz.
Just want to thank the subgroup. I mean, you took this on, you've put a lot of work and effort into it. And I know we're focusing on our areas of disagreement here, but I want you to take a look at this and how much we must all agree upon. And maybe that frames the vote that we're going to take later on, because there's a lot of things that have not received any comments, which I gather, I hope, means that the group is largely in agreement on. So again, thanks for this to the subgroup for taking this very difficult task on.
Oh, thank you for the kind comments, and the glass is half full encouragement to think that way. All right, so are there any other, is there anything that we missed in terms of comments on
All right,
these definitions? Yes.
Sorry, I have a comment also on the table. I think Dan mentioned the same, but I'll hold it until later.
It's not that I want to cut anybody off, it's that I don't want to lose any of our members because they have to leave.
All right, so Judge Pichon, I think hearing from those 2 people might be helpful, and then we can decide whether to carve out this qualifying peer feedback section and vote on that separately. Is that
very good? Go ahead.
Okay. There were 2 hands up. People who were wanting to comment on on things on the table. Okay, good. Jenna.
Thank you. I just wanted to renew and re-express my concerns about including a sunset provision for the path for experienced mediators. And I wanted to draw to the attention of the subgroup the general principles that we voted on in June. And in those general principles, we do have Principle 3, which says that the baseline requirements for very experienced practitioners should generally not require as much training. However, very experienced practitioners should be required to have completed a specified amount of training in a specified time period. And of course, we would assume, and as your chart, rightly requires, some higher amounts of experience for that column. So I just wanted to restate my position regarding removing the sunset provision from that third pathway. Thank you.
Thank you. And Cliff.
My comment applies to both mediation and arbitration as it relates to the renewal. I think we need to understand, or at least discuss at some point, and maybe not now, what happens with regard to renewal if people are found guilty of having violated the ethics rules or have too many complaints. That's the whole point of this, and I'm not sure we've attacked that issue yet.
Oh, thank you for that. One of the discussions that we did have related to someone mentioned, what happens if maybe it was you, Cliff, about what if you do have a contingency fee agreement and violate the rules? What are the consequences? And we realized that that question is better handled in the complaint process. In fact, there is a complaint committee, and that deferring to the complaint committee on this question of what are the penalties is perhaps the most appropriate way to proceed. So we didn't address it.
Makes
Is
sense.
that helpful?
Yeah, thanks.
Okay, thank you. Daniel.
Thank you. I'm not against this. I'm just curious as to the reason. For experienced mediators, there's people on this panel who have literally done thousands of mediations, and thousands of arbitrations for that matter. Some of those experienced mediators have also provided thousands of hours of training. And I'm curious as to why we would require another 4 hours per year, 8 hours per 2-year period.
Another 4 hours per year of training?
Yeah.
I mean, we believe that people, I'll speak for the subgroup, that keeping up and being engaged in the profession as it develops and new skills and understanding and learning, is important, and part of professional development is ongoing learning. That, in a nutshell, why we would require it of even people who've worked in the field for a long time.
And
certainly teaching a class would qualify. I think those things need to be spelled out in the administrative portion of the administrative rules for that subgroup.
Right. And that was the other part of my question. Has qualifying mediation training been defined?
No.
Okay, thank you.
Well, except for the 40-hour training. And anyway, there is some definition that we've circulated previously for what qualifies, but yeah. In fact, Alan has up there. Alan, do you have it? I guess you took it down, but never mind.
See it again.
Anyway, we had spelled that out previously, what constitutes appropriate training going forward. It's much broader than that.
Right. Okay.
Although it does mean that you need to have 2 hours of ethics training, since that's the emphasis of these rules in the first place. All right, any other questions? Did that answer your question, Daniel?
Yes, it did. Thank you. I read it. I don't know why I didn't remember it.
Oh, well, happens all the time to me. Thank you. And anybody else? All right. Well, Judge Pichon.
All right. Ms. Curtis, thank you. That was a wonderful, spectacular presentation. You did an excellent job of fielding the questions and being very kind and patient and providing great answers to the questions. So I'm going to leave it to you as the lead to tell me if you would like to exclude the sessions that receive the most comment, and that would be the reflective session requirement and also the requirement for the joint session. Would you like to exclude those to a vote, keep one or the other or both, and have the group vote on whether that can go out for public comment? As I said earlier, if you take something out, the staff can always pinpoint it when it goes out for public comment outside of the entire recommendation. It would be its own separate little area. So it can still go out for public comment, even though the group does not want it. And then the group can hear what other stakeholders and interested people, how they feel. So I'm going to leave it to you to tell me how you'd like to proceed, Ms. Curtis.
I would like us to vote on the qualifications for mediators that include the definition, the table, everything on the table, and then the definition for qualifying mediations. Oh, I guess we need a motion to exclude number 3.
If I may, Judge Pichon.
Yes.
We need a initial motion, I think, from you or from someone to move this forward we've discussed it, but we also need a formal motion before we vote, and then a second.
Okay.
Yes, but let me just clarify. We need a formal motion to vote, but will that formal motion include, what will it include?
Well, if she can start with the formal motion, and then if we can include procedurally then a motion to amend this document that we were just reviewing, because this was what was presented on the agenda. So there should be a motion to amend this document.
Actually, if I may, I'd like to make a motion to have a vote on the document as we proposed. I think that if I'm doing a nose count, it's going to not be approved, but there are a lot of people who maybe haven't commented. And I think that would be pretty quick. We could go through it and then we could make a motion to amend. Does that make sense? And if anybody seconds, and if it doesn't get seconded, then I guess it doesn't make sense.
Lucky, I'll second.
All right. So Ms. Kopaken, that was a motion that you made to vote on the entire recommendation. And then Judge Lucky, you have seconded that.
May I make a friendly amendment and see if the author will accept it?
Yes.
To include joint sessions, at least in the training requirement.
I think that to clarify, I was proposing that we just vote on it as we presented it. There's been some discussion about moving the joint session. So I think my proposal intends to include it as it was in item number 3. We can talk about what a next motion would be.
And my second,
no, thank you.
and my second was to Ms. Kopaken's motion as she just stated it.
All right.
So just to be very clear to the entire group, what we are voting on includes peer feedback, includes a requirement of a joint session, and does not include joint sessions in the training requirement, correct?
That is correct.
Cool, got it.
Ms. Marlott, would you call the roll?
Sure. Armstrong,
No.
Coulter,
Yes.
Curtis,
Yes.
Dinkin,
Oh.
Dubois, Mr. Dubois.
No.
Thank you. Ellis,
No.
Dr. Getz,
No.
Higuchi,
No.
Hodgson is absent. Jones,
No.
Kelly,
Yes.
Kopaken,
Yes.
Cruz,
No.
Lowe,
No.
Judge Lucky,
Yes.
Pileski,
No.
Robertson,
Yes.
Tuckman,
No.
Welch,
Yes.
Yamshawn,
No.
and Judge Pichon.
Yes.
So we have 8 yeses and 12 noes, so the motion fails.
Thank you. All right.
Thank you.
May we have another motion?
I'd like to move the same text, but adding training, requirement for training in joint session.
Is
If
there-
I may, as the last one just failed, I think you are going to get a very similar vote. Perhaps like removals of some things and additions of some things might be more successful. But
In reference to my colleague Diana, I withdraw the motion.
perhaps the next motion, and I defer to the group, but could be something like, let's add it to the training. Let's remove it from the certification requirement. Let's remove the requirement of peer discussion.
If you will turn that into a motion, I will second it.
Sorry, that was my intent, subject to the group's feedback if it needs to be modified further.
Except you said the word it.
The motion.
What is it referring to?
So a
take-
motion to approve, and I'm sorry about the feedback, it's not coming from me. A motion to approve their subgroup's recommendations, but with the following amendments. So we would remove the joint session from the third bullet point in the requirements for certified mediation. We would, however, add that joint sessions are an important piece of mediator training. And then we would remove all of the requirements of reflexive peer feedback. So that entire column that Alan's scrolling to the far right.
Is there a second?
Second.
Dr. Getz, you have your hand up.
I wanted to make a friendly amendment and separate out the peer feedback piece from the joint training piece. And maybe we can just vote on the joint training and the peer feedback separately.
Joint session.
Does the mover of the motion accept that amendment?
Yeah, I think that's a slower way to do it, but I have a feeling that we're all going to be aligned on the joint session and training. So I defer to the chair.
All right. Then if you accept the friendly amendment, then we'll just ask the second. Does the second agree?
Yes.
All right. So the motion that we're voting on now is as presented by the subgroup, except that we're taking out the requirement of a joint session and inserting that into the training. Is that accurate? Okay. It appears that it's understood. Ms. Marlaud, would you call the roll?
Yes.
I'm sorry, before you call the roll, so we are voting to include, if a yes vote here is to include the peer reflective practices?
It would remain in the subgroup's recommendation, yes.
Until the next motion.
What?
Yes.
I guess I'm,
Mr. Armstrong?
okay, so we're okay, I think I understand what we're trying to do.
Yeah, and just to be clear for everyone, we are all this would include the reflexive practice group discussions if you vote yes. So a no is a no on that.
A no is a no on the joint.
B26.
Yes. A no. I'm sorry.
Okay, thank you.
I'm sorry, would you repeat that, please? Because you said it right. I think I might have messed it up. So please state it again.
Sure. So what we're voting on right now is all these 4 requirements, or the 3 columns that you see, including an affirmative requirement of peer feedback. But if you go down to the next page, Now we're saying, yes, we want joint sessions and training, but we do not want it in the final qualified mediation definition, which was prong 3, I think, on the page following. And I know Alan's trying to kind of get this into a even bigger layout so you can see all the changes.
Thanks for bearing with me on that.
And I gotta say, folks, I didn't hear any dissent on joint sessions and training. I think to avoid a third vote, it's probably faster to remove the peer feedback and see what happens, but
Yeah. I agree with that. I would second that motion. I think it's already been seconded and then amended, but
yeah.
Thank you, but no, let's please stay in order. Unless the mover and the seconder agree.
Well,
we're
I
gonna-
was the initial mover, so I think I want to stick with my initial motion. So we remove the peer feedback, we include joint sessions and training, and we remove in requiring a joint session and qualifying mediation definition. And if this one doesn't fail, then we'll go to the third. If this one fails, we go to the third permutation. But I think the second one's kind of confusing to a lot of people, which is why you're getting so many comments.
As the seconder, I agree with Ms. Cruz's motion.
All right.
If I may, Ms. Cruz, do I have that, how you want to see it on the screen?
I think that's right, Alan. That makes it very clear, I think, on what we're voting on, so people can decide where they're at.
Okay. Are we good to go? All right, and Ms. Marlotte, would you please call the roll?
Armstrong,
yes.
Coulter,
No.
Curtis, Dana, you're on mute.
No.
Dinkin,
Yes.
Dubois,
Yes.
Ellis,
No.
Dr. Getz,
Yes.
Higuchi.
Oh.
I'm sorry, Dario, I couldn't understand you.
No.
No, thank you. Hodgson, Jones,
Yes.
Kelly,
No.
Kopaken,
No.
Cruz,
Yes.
Lowe,
Yes.
Judge Lucky,
Yes.
Palevsky,
Yes.
Robertson,
No.
Tuckman,
Yes.
Welch,
No.
Yamshawn,
Yes.
Judge Pichon.
Yes.
12 yeses and 8 noes, so the motion carries.
Okay.
Can I make, sorry, another motion, Judge Pichon?
Yes.
Let's, if it's okay with the group, and maybe I don't need a motion on this, but I think it, especially since 8 of us voted no on this, putting out like the things we deleted for public comment might be helpful, because even though there are 20 great minds of us, I would love to hear from consumers and litigators and other ADR professionals on all these things. And so I don't think it hurts much to put it in kind of another section, and invite the public to tell us if they agree or disagree.
Very valid and good point. Ms. Ellis or Mr. Weiner, is that something that staff can just do without us making a motion?
Yes, we can.
Okay, so that will be done, and thank you for that suggestion. And I think it is important to hear what the stakeholders and the public, how they feel. Mr. Kelly?
As the person who brought up the point originally, I wonder if staff might, with the working group's approval, phrase that as preparing parties for and conducting joint sessions. That'd be my suggestion about how staff phrases that.
So that's fine.
I don't
Staff
know if that requires a motion.
It does? I don't think so. Staff, I think that's a suggestion that the staff has heard, and that they will consider when stating the issue to the public for public comment. So I think that your statement is good and it will be considered by staff. Okay, great. All right, so Ms. Curtis, very good. Staff, I think that we can now move along from this subgroup, except that we do have the rules at the end, but we're not there yet. So, Mr. Weiner, there are two hands, before I take them, could you help me with the next step?
Sure. Excuse me. I think there are a couple of options, Judge Bashan. If you wanted to, you could take item 3 out of order, which is the ethics standards, and that would be the conclusion of the mediation subgroups reports. Otherwise, you could proceed in the order of the agenda and take up the arbitration subgroups recommendations at this point in time. I think that's at your discretion, Judge.
All right, great. Let me hear from the people whose hands are up. Ms. Kopeikin?
Thank you, Judge Bashan. I need to leave when scheduling. I called out this conflict. So I apologize. It's not that I'm uninterested in the arbitration practice group's work, but I cannot stay. If I can give a proxy to anybody for any voting, I would, but I don't know if that's appropriate. No, it's I thought not. All right. Thank you so much. Thank you all.
Thank you for your participation, and I understand that you have to leave. Thank you. Mr. DeBoe?
I'm confused. I thought we were going to vote on striking the peer reflection also from the.
We did.
We did?
Yes.
That was both, it covered both?
Yes.
Oh. Well, I stand corrected.
That's all
I
right.
hope I voted right.
All right, so now I know you all want a break, and I want to take out of order number 3 on the agenda. Ms. Curtis said, at least it's still on when we get back. And I'm sorry about that. You've done a wonderful job, and I'm sorry. But I know that you all need to take a little break. So can we have just like 10 minutes? And then during the break, would you please, those of you who are not able to read the minutes, would you read them so that we can take a vote? And we'll just take the vote at the end of our session. Okay, so we'll take a brief 10-minute break. Thank you. All right, Mr. Weiner?
Thank you, Judge Bashan. So we'd like to have the working group vote on a resolution to adopt in concept the attachment as it was amended in the working group and to go out for public comment in that form. And I am going to try and share that resolution.
So moved.
And that was Mr. Kelly. Is there a second?
Dana Curtis, I second the motion.
Thank you. And any discussion? Ms. Marlaud, would you please? Oh, Mr. Tuckman, yes.
I do have a question. It's approved for the purpose of circulation, correct?
Yes.
At the bottom?
That the requirements be circulated for public comment. Yes, what is your question?
So I think we're not necessarily voting to approve this document for adoption. We're voting to approve it for circulation.
Yes.
That's right, if I may. Yeah, Mr. Tuckman, that's why this is the same language that was done, used with the approval of the complaint procedure, that it was being approved in concept, and be circulated for public comment. I take it what, well, let me ask you, if that's not acceptable.
Yeah, I read this as us voting to approve it. In addition, circulating it for public comment. If this is not an issue for others, it's fine. But I do think we want to make sure that we've said along, this is not a vote final approval. We're not all, I think, individually voting for it with that intent. We're just at a point, I think, where we agree this is ready to be circulated.
Yeah. Alan, I think if you remove the comma after the word approve, it'll remove any ambiguity. There you go.
And I think wouldn't the other comma need to also go following concept?
No.
Okay.
Yes, you're right. You're right. You're right. It does.
I think that's right.
Yeah. Okay.
So that reads a little better to me anyway.
The maker of the motion accepts that as a friendly amendment.
And the seconder?
I'll
Ms. Curtis?
second.
No, Ms. Curtis already seconded. I'm asking if she
I'm
accepts.
sorry.
And you're muted, Ms. Curtis.
Okay. All right. So just to let you know, is it time for me to start?
No. Do you accept the amendment taking the commas out?
Yes.
Oh, okay. All
Sorry.
right. That's okay. Ms. Marlowe, would you please call the roll?
Armstrong,
Yes.
Coulter,
Yes.
Curtis,
Yes.
Dinkin,
Yes.
Dubois.
Yes, and my video has been disabled by the host, so you can't see my handsome face.
Okay, I'll fix that after the vote. Ellis,
Yes.
Dr. Getz, Higuchi,
Yes.
Hodgson, Jones,
Yes.
Kelly,
Yes.
Kopaken, Cruz,
Yes.
Lowe,
Yes.
Judge Lucky,
Yes.
Palevsky,
Yes.
Robertson,
Yes.
Tuckman,
Yes.
Welch,
Yes.
Yamshawn,
Yes.
and Judge Pichon.
Yes.
The motion carries.
Thank you. All right. Thank you, staff, for that. All right, Ms. Curtis, you're back on with item number 3. We'll take the minutes after your presentation is completed. And item number 3 is an update report and action on ethical standards for State Bar certified mediators. I'm going to turn it over to you, Ms. Curtis. Thank you.
All right. Thank you, Judge Pichon. So we first circulated a couple of months ago a version of the new the standards as applied to certification, the mediator certification. And you've had a chance to look at that. For the most part, it consists of changes that were made to make those standards applicable to certified mediators. So it didn't involve any substantive changes. I wasn't planning to have Alan put that up as a screen share to show all of the redlining. And so I'm going to assume, unless I hear from someone otherwise, that the changes that were for that purpose are acceptable. And so I'll take a minute and see if anyone has questions about those kind of efforts to conform it to this purpose as opposed to court-connected standards of conduct. Anyone have a question? Okay. And then we also considered a number of substantive changes, and I think I mentioned those in one of the reports that I gave to the working group a while back. And ultimately, the majority, the strong majority, did come up with 2 substantive changes that we would recommend be made to the court-connected rules for the purpose of mediator certification. One is to clarify the mediator's duty to disclose matters potentially affecting impartiality, and the other concerns whether the mediator's acceptance of new matters, it concerns the mediator's acceptance of new matters while a mediation is pending. So there are really 2. And Alan has created a helpful highlighted version of the rules as they exist and have been rewritten. And Ellen, if you could do that, put that up on the screen.
Yes. Sorry, I had a different version that I was trying to put up, but give me a minute and I
Oh,
will.
no, you can put up whatever you want. That's fine, as long as we can, I think there were a couple that you do whatever is easy for you, because it's the information's the same. The other thing I want to mention is that, there are rule numbers for the existing court-connected mediation rules for mediators, and they've been renumbered, and I'm going to be referring to the renumbered version that would be put out for comment. And it concerns section 6, if anybody wants to look. Okay. So there's one change, and that is that, well, let me read the whole thing. A mediator must make reasonable efforts to keep informed about matters that reasonably could raise a question about his or her ability to conduct the proceedings impartially, and must disclose these matters to the parties. These matters, include past, present, and currently expected. Okay, that's okay. Currently expected interests, relationships, and affiliations of a personal, professional, or financial nature, including past and currently pending mediations for a party or a participant. The highlighted portion is the proposed recommended amendment. And for your information, this particular language was taken from the advisory comments to this rule, and the advisory comment. Sorry, I'm skipping around too to my notes. So the majority strongly believes that mediators' involvement in another mediation could reasonably raise a question about his or her ability to conduct the mediation impartially, and that consumers need this information to make an informed judgment about whether they trust the mediator to be fair. And just to be clear, this isn't the change doesn't in any way imply that a mediator is impartial because they've had other contacts or mediated other cases before. And so that's just one thing that we want to make sure that we're clear about. It's just that a consumer could reasonably conclude that the mediator couldn't conduct a fair process if this information was presented to them, and so they have the right to make that decision, and that the information is required for them to make an informed judgment. The minority strongly objects to this disclosure requirement, believing that it's unnecessary in the context of business mediation because it's universally accepted practice for mediators to routinely serve the same parties and lawyers. And that's just understood. And second, the effort it takes to investigate prior relationships in order to fulfill this obligation is overly burdensome, especially when compared to the minimal benefit. And then finally, the minority is concerned that this requirement may discourage mediators from seeking certification. I'm sorry, that was third. And then fourth, many mediators will view it as not substantially advancing any ethical objective, and the disclosure will involve merely pro forma language in mediator engagement letters. So that's that sort of sums it up. And I'd invite my fellow members of our subgroup to comment if you wish. No. All right, Cliff.
Well, first, I'd like to thank this subgroup because I think you've done great work on complicated things. There's a real big, I have questions more than anything else because there's obviously a big difference between mediation and arbitration in terms of impartial and the perception of neutrality. Couple of things. I'm not exactly sure what impartiality means. You mentioned to conduct the hearing impartially, which I understand. But I'm not sure what impartiality means in a mediation because there's different styles and some people don't think they're supposed to have an opinion and some have very strong opinions. And sometimes you got to look at someone and say, you know, your claim is not going to win or you're making a big mistake. So I'm not exactly sure what impartiality means in this regard. I think disclosure up to a point is good. You know, obviously in mediation, we sometimes say, who do you like? And you want the mediator to have credibility in the other room. So it's not a matter of, do you know the person? But if there is going to be disclosure and recusal, which you have later on, in, you know, under certain circumstances, I think we need to figure out how that impacts fees. Mediation is a strange one because, you know, a lot of mediators say, you know, send me 20 grand up front, and if you cancel within a certain period, you don't get your money back. And so I'm not exactly sure how continuing obligations to disclose and discomfort may interact with that. I don't know that there's an answer yet. I'm not exactly sure how mediators' proposals fit into these ethics rules. You say refrain from coercing any party, which of course is appropriate. But a mediator's proposal is sort of a lack of, if you will, not necessarily impartiality or neutrality. I'm not sure how it fits in. I like mediator's proposals, but I'm just confused a little bit how that all fits in. And also the definition of pending isn't very clear to me. There was a definition earlier that said it starts when the mediator says okay, which could be 3 months in advance to when the parties say it's over. And I'm not sure whether that would encourage people to say we're done today to free them up, or at what point, what does it mean to be pending? So those are basic questions that arise, but I think in general, great work.
All right, so let's start with number one, which is what is impartiality in the context of mediation? And here it is to conduct the proceeding impartially, as opposed to being neutral. And, you know, one definition is that you're partial to all parties equally. But I think that's a little facile. So it's that, you know, just despite the kind of tendencies we have to be drawn to one point of view or one party more than others, that we can be fair in conducting the process. So giving people sufficient time and an equal degree of ability of working to understand and so on. I mean, we did talk about whether to clarify what is meant by coercion, and decided not to do that, or to further define coercion. And so I think as long as the as the mediator, isn't pushing and forcing a party to give up their voluntariness or that kind of, I mean, it's a spectrum from, informing and to coercing, and it's hard to define it. I mean, but I do think that as it's constructed, it leaves room for lots of different styles and approaches, as long as the mediator isn't imposing his or her view to the exclusion of the parties and using, coercive means or fear or that kind of thing to get them to settle.
A lot of clients feel coerced. I understand the distinction, I think, in forcing somebody, but coercion, I'm just saying, as an ethical rule, that line is sort of vague in how lots of mediations are conducted and how it is perceived. But okay.
Well, I would like to say about so many of these things that it really emphasizes the importance of training. And it's one of the reasons I realize that, the majority's, it's gone now, but one of the reasons, the strongest arguments for reflective practice groups is that it allows the opportunity to discuss the nuances of ethical decision making. And so, the 40-hour training programs do that. And that's the other reason we required the ongoing training in ethics, because it's a very complex process to respect all of the tenets of mediation, and so, yeah. Anybody want to take on another question of Cliff's? Because I would love to share the floor here. Alan.
Mr. Weiner.
Thank you. I was just going to kind of reinforce something that Ms. Curtis said about, just for context, the statute requires that the ethical standards for the state bar certified mediators be substantially similar to the rules of court governing rules of conduct for mediators and court connected mediation programs. So for the most part, the subgroup kind of accepted those as given, and it's really just these couple of provisions that are highlighted here that reflect changes that the subgroup wanted to propose. And so coercion, it certainly has a relationship to impartiality, certainly. If the mediator is coercing a party, if a party feels coerced, the party is not going to feel like the mediator is acting impartially. But there is a separate standard that relates to coercion. And Mr. Polewski, I don't know whether some or all of your comments about coercion might be addressed by that other rule or by the advisory committee comments to that rule.
Ms. Curtis,
hard to define.
I turn it back over to you, Ms. Curtis.
Thank you. Yes, Ron.
Thank you. I know there's been a lot of controversy about the disclosure requirements by high-end professional mediators who say I'd have to have 500 pages. And I just want to strongly support the working group's decision to leave this and, if anything, strengthen it, because what Senator Umberg, the author, referred to as disclosure transparency was a central reason for passing this legislation in the first place. And if we don't do it this way, I think the legislature's next move may be a good deal worse. For instance, arbitrators have to disclose some things under penalty of perjury. And our current rules of court expressly say that they're not supposed to be used as a basis to throw out a mediated settlement. And I think that's a really important thing to include. So I want to strongly support all of these disclosure requirements. I do think that Cliff, my learned colleague, Mr. Polewski, brought up an important point which is not covered, which is really challenging, which is what if you spend a whole bunch of money, you're 3/4 of the way through, somebody brings in a new party or new participant, and somebody says, okay, I now no longer trust the mediator's ability to be impartial. I want to end this. The mediator has to withdraw. Who pays all the money for all those lawyers and expert witnesses and stuff? That's not covered. It's a really challenging issue. And I don't know if we're capable of covering that, but I think Mr. Polewski brings up a really good point about fees. Thank you.
Thank you, Ron. And that brings up the other question. The rules as they're written also says that these disclosures must be made at the, well, I guess that's the portion, at the very earliest possible point. And if you look at the first, at section 6.1, it says reasonable efforts. So, you know, nobody's expecting you to do things that are impossible in terms of this information. And then also we've recommended a change to an addition to the administrative requirement that mediators keep documentation that states, you know, the parties that they've worked with, and so, you know, that there is not, you know, from the point at which they're aware that this is a requirement, they'll be doing so going forward. It also, you know, is you know, so it's, you know, that gives some flexibility into how hard parties work. Most of the time, sometimes I don't recognize names, but I've always disclosed them. And one of the things we became aware of as we began investigating all of this is that there's a that some parties, some mediators do this as a matter of routine and take this on as an ethical obligation in any context of their practice, not just court conducted cases, and that others don't, they routinely don't do it. So anyway, that was part of the impulse for our proposed recommendations. Yes, Katie.
Thank you. You know, when I do have concern about accessibility in this program overall. I find a lot of it to be somewhat onerous, especially on the part of the practitioner. And I would have substantial concerns about like a solo practitioner who really has focused traditionally just on mediation, and, you know, doesn't have the overhead of a staff to be able to provide the kind of disclosures that you're talking about. Candidly, when neutrals interview with ADR services to consider joining our panel, you know, we ask about their client database, and unless they have previously built an arbitration practice, the majority of them don't have anything, and don't do that as part of their practice, and don't consider that a responsibility or requirement, maybe for marketing purposes, but they don't keep that kind of detailed records. So I would be very concerned about the kind of initial startup costs for something like that, for somebody to take it on. And would just like the group to be cognizant of that, you know, we do want to keep mediation accessible to all levels of practitioner here. Another note, you know, even for a big provider firm like any of the major ones, of course, we have the functionality to do this. Would we then pass that cost on the customer? Probably. So from a consumer perspective, there is a consideration there if you want to institute a very formalized disclosure process for every single mediation. That's just a thought. I have no concept of how much that would cost. And then finally, I would be interested in hearing the subgroup's perspective on how confidentiality in disclosing currently pending mediation cases to an active party works.
Okay, thank you, Katie. Paul?
See a problem for making a disclosure on the part of the mediator. In fact, Katie points out that the small mediator may have a difficult time maintaining a database. I think it's even more important that a mediator who has a smaller practice make these disclosures, because if I were an attorney or party to a lawsuit who wanted to engage in a mediation, I would want to know who the mediator dealt with in the past, because that mediator may want the business of that person. And if I don't have much business, a mediator with whom I had business, has a higher percentage of my business than does a person who has a lot of cases. So personally, from my personal experience, since I consider myself a one-man operation with respect to mediation, I had no problem creating a database on my own. It was very simple. It was not as high class maybe as some of the ones you see, but it was enough for me to tell people who hired me as a mediator of any contact I had with the parties or attorneys in the current mediation. So I don't think it's a big problem. And I do believe that we can require all mediators to make disclosures and it won't be a burden on them.
Thank you, Paul. And I'll just add that I've been mediating pretty much, except for a little bit of 4 years when I was with the court, mediating in a solo private practice. And it's been fairly straightforward for me to search back many years to, and I don't have a database. I just go into my files and type in a name to see if it's just like any conflicts check that one might do. Thank you, Paul. And Diana.
Yeah, just following up on Katie's point, and then I have a question too. So if I'm suing my employer Target and my mediator Paul also has a case, where Maddie's suing Target and also another case where Jenna's suing Target for, sexual harassment, is there a confidentiality concern where you're going to kind of turn potentially a case into a class action by making these disclosures or benefit parties by doing so with information that they wouldn't necessarily normally be required? I do wonder about that confidentiality concern. And then the other question is would this apply to providers too? So, for example, do you have to disclose all the other neutrals, past and currently pending mediations with a party? And I guess participant means a lawyer or a representative, so a lawyer or a law firm.
All right, well, taking your last question first, it would mean a lawyer. Second question, I assume that your question will be addressed by whatever subgroup discusses recommendations for providers. But I would say that that wouldn't be a disclosure requirement if I had to make the decision. And third, the first question, it's the disclosure can be as simple as I must disclose that I've worked with other parties or lawyers, other participants in this mediation in the past. And you don't even have to say who. Now, if you have two parties, but you still have four people in the mediation. So, I don't, and the comments, by the way, to this provision say that you do everything you can to preserve confidentiality, and if there's no way to do so, that you must refuse the mediation. That's how they handle it. Nolan.
Thanks, Dana. And thanks to all my subgroup members for the hard work in putting this together. So as background, I was the dissenter on this.
I'm sorry. Oh, yeah, go ahead.
As background to the entire group, I was the dissenter on this. And I think Dana very clearly laid out my concerns with what's being proposed. And I think first and foremost is my concern that in sort of the commercial mediation space, and particularly the experienced mediators who do volume practice, hundreds of mediations a year, year after year, and who were already imposing pretty significant training and education requirements on to become certified, which I think are well intentioned. When you add these requirements onto it, I'm concerned that as a whole, the reaction in the industry is going to be you know, this is too much for me. And it's not a worthwhile use of my time, given how much business I already have to become certified. So while I can get sort of in the ideal world, it'd be nice to hold everybody to these standards and make that sort of the common practice. I think the reality is, unless we get significant buy-in amongst the mediation community, then having a relatively select group of people being state bar certified doesn't really advance the objectives that we were formed to put forth. And and then that's just my experience from not only being in sort of the commercial space, but also having mediated regularly with commercial mediators before I joined Signature at the beginning of the year. I never once asked somebody how often they'd worked with the opposing party or if they had other cases pending. I just think that these kind of things end up getting worked out in the marketplace themselves versus being some rule or requirement we need to impose upon people.
Okay, thank you, Nolan and Ron.
Thank you. I want to speak to Diana's point about confidentiality. Way back in '96, when we were crafting the confidentiality statutes, we debated long and hard this exact situation. Would disclosure in an employment situation turn it into a class action, as for example? I'm getting some feedback from somebody. Could you all mute, please? And what we came to the conclusion was we were really in favor of disclosure and of parties and of being able to know, I don't want to use this mediator or I do. So the chapter specifically says this chapter does not limit disclosure of the mere fact that a mediator has served, is serving, will serve, or was contacted about serving as a mediator in a dispute. We tried to make that really clear which way the statutory preference was, and that was for disclosure. Thank you.
That makes a lot of sense, Ron. Thanks.
Thank you. Thank you, Ron. Jenna.
Thank you. And I neglected to say it earlier, but I do want to extend my thanks to the extensive work that the mediation subgroup has put into this. I can tell, it's a big endeavor, and I am very appreciative. I guess I have a couple questions. And maybe it's partially coming from a background with more exposure to arbitration disclosures. But I guess first, was there any thought on any limits in time? Like how far back would a mediator be obligated to search their records for past cases with a particular party? And secondly, and I think, some of Nolan's and your comments too, Dana, have referenced this, is the idea to make essentially a disclosure along the lines of, I have had past cases with Target. I have had 10 past cases with Target, and I have 2 current cases with Target. Or would it be, is what envisioned a list of all of each and every one of those past and current matters?
Well, there would never be a list of all of those that would be required. What we did discuss is that that if a mediator has mediated a single case, they can say that. And if they've mediated multiple cases, they can say, I've mediated multiple cases, or you could disclose the number of cases. And that was somewhat of a compromise, because some of us felt like the mediator should disclose how many cases they've mediated for a particular participant. And I forgot your first question, and I didn't write it down. So sorry.
No problem. It was just clarifying whether this was for the entire time that someone has been a mediator, or whether in the arbitration context, for example, there's kind of limits in the universe of time for the disclosures that are made to parties.
Well, the statute says reasonable efforts, and we did discuss how to clarify that. For example, reasonable might be 5 years back. Or if you don't have a database, it might be a different number. And maybe someone else in my subgroup would like to address this. Anybody? Okay. Yes, Judge
Sorry,
Lucky.
I don't have a virtual hand. I just wanted to mention that the subgroup um, looked at a draft of much more extensive provisions covering things like what the limitation of time would be, whether, as Ms. Curtis said, whether the disclosure should be of the number of cases or simply whether it was one or more than one. And ultimately, the subgroup decided to go with simplicity and leave some of these matters to be sort of worked out in practice, if you will, within the guideline of just saying including past and currently pending, rather than saying, within the last 5 years, or, what information must be disclosed, whether it's the name of the party. I mean, I'm not even sure if there's a case involving Target has been the example. A mediator might not need to disclose that they have mediated cases specifically for Target. If there are other parties or counsel in the room, it might be much more general than that. I guess that's all I'd say.
Thank you. Judge Lucky?
It seems to me that if CCP 170.1 for the disqualification of judges says within the past 2 years has been a lawyer for a party, and after that 2 years has passed, is no longer disqualified under 170.1, but may have some disclosure requirements. 2 years seems to be a decent benchmark.
Interesting. Thank you for that. Diana?
Yeah, I was going to say the arbitral disclosure rules, depending on what sort of disclosure it is either 2 years or 5 years back. And so I would second Judge Lucky's, and Jenna's, let's put a specific time on this. Also, I just wonder, team, like the tension between the non-disclosure disclosure. So like in Dana, your example of like, well, I've worked with one of these people before, that's kind of a non-disclosure disclosure to me, right? It's like, who did you work with? And then on the flip side, too much disclosure runs you into the confidentiality problems. And so leaving it up to the neutral might be a good idea. I don't know. I'm interested to hear the group's feedback. But I generally I appreciate the specificity on the arbitrator disclosure rules because it tells me exactly what I need to disclose, which is nice. And that gives me certainty that I'm not going too far or too little. So just an idea for the group.
Thank you. And from Ron's previous discussion about the creation of the rules, the confidentiality, the evidence code rules, it sounds like saying I mediated for Target wouldn't be a problem, or a particular lawyer. The other thing that I've done too is to say, is to encourage the other lawyer to say, to disclose it as well. And then I do it as also. So now there are a lot of ways to handle it that respect confidentiality. All right. So any further comments about this particular recommendation? Chris?
Dana, thank you so much for everything that you've done today. It's been amazing that you've been able to carry our program and carry our proceedings. And so that's one dimension. And thank you for everything. I think there's one piece that I just have to speak of because I've been brought to my attention by DERPA agencies, right, in the DERPA statute. And I know that I didn't bring this up in our proceeding, but it's something that's recently happened. And it's just a provision about the confidentiality and anonymity, or the anonymous of the parties, right? That is a 467.6 is regarding confidentiality of parties. And I just want to bring it up because it might be a concern of DERPA organizations, and we just need to address it because they brought it up about that. And so I know that's a context of disclosures, and it also comes into keeping names and all those pieces. It's just a piece that I wanted to mention. We could probably get over that hump. I just wanted to mention it as something that was brought up about that by DERPA organizations.
Yeah, thank you, Chris. And Alan mentioned a little bit ago that we had a longer, more complete description of what was required, and that also accepted DERPA day of court mediations. And I don't know if this would address that concern particular, Chris, but I mean, we may want to come back to you with, I'm probably going to be shut down for saying that, don't we want to finish? But, you know, those, we could offer those up because they were pretty thorough and address many of the things that you're concerned about.
And I'm just really concerned that we still need to get to the arbitration subcommittee. And I see there's another hand, Ms. Curtis.
Yes, Katie.
Oh, I can be brief. You know, I assume that in your many conversations, the subgroup considered the question of insurance companies. But from an administrative side, you know, quite frequently, we have no idea who is involved in coverage. The parties don't even know who the other side has coverage from. So maintaining them as participants creates quite a quagmire for us in these circumstances.
You are right. We did discuss this and that we did not, we thought about accepting insurance companies. But I think the current language whereas parties or participants, meaning individuals, you know, could handle it, but that's another thing that could be clarified more than it is now. And Dan, is this something new, Daniel? No, okay.
I just wanted to add that in certain kinds of cases, if you are going to get to closure, you need to have an adjuster either present or available throughout the mediation on the phone, because if they don't understand the progress of the discussions of the mediations, the reaction at the end is going to be, you agreed to what? So when there are carriers involved, even as a source of authority, then they should be entered into your database, I think.
Thank you. Judge Pichon, how would you like to proceed?
Have you finished your presentation, Ms. Curtis?
No, I'm sorry to say. There's one more recommendation that we had, and I can introduce it and then see.
If there are any questions regarding it.
Yeah.
Okay, please do that.
Okay, and that has to do with I'm sorry, I lost track of my notes here and I wanted to not, okay, accepting a new matter while a current mediation is pending. And we discussed at length whether to amend Section 9, marketing, which prohibits mediators from soliciting new business, and adding the word soliciting or accepting new business. And there were some, you know, the majority of us were in favor of that, but there was disagreement. And so we, rather than pursuing that avenue, we looked to the arbitration ethical standards, which require arbitrators, and we would adopt it for mediators. When or before agreeing to serve as mediator in a new matter, and the mediator must disclose whether he or she may agree to serve in any professional capacity, including as a mediator in any new matter involving a party or a lawyer for a party while the new mediation is pending, or the current mediation is pending. So that's a recommendation.
Okay.
And
Does
that,
go ahead.
There was a minority view that would be overly burdensome, and for many of the same reasons that that we discussed before as relate to disclosing numbers of cases or cases that you've mediated before. Thank you.
Okay, thank you very much. So I do see a hand up, but I want to remind us that the question, the bottom line, is whether or not this proposal or recommendation can go out for public comment. We will be discussing all of this again and what comes back from the comment from the public. So I see another hand, Mr. Palevsky.
Yeah, I'll take it down if you want to move on. I don't want to use the arbitrator rules as a model because I don't think they're good enough. But more importantly, the obligation to disclose is continuing here. And it literally says that if someone objects, which could be in the middle of a mediation or during the pendency, you must affirmatively withdraw. And I just want to, just from experience, watching all of that play out. I think it's complicated. Without standards as to have a mandatory withdrawal based on an objection based on. So I'll let it go out for comment and try to refine it, but I can tell you that's going to be a problem.
Okay, thank you. And Ron?
In the interest of time, I'd like to call the question.
Fine. Okay, go ahead. Who
I
would like-
move that the subgroups recommendations be adopted in whole and that we already adopt a resolution paralleling the one we did earlier on the earlier subgroup recommendation.
All right, so Mr. Kelly, you said adopted, and I know you're very particular about words. Do you mean that it can go out for comment?
Yes, ma'am.
Oh, thank you. I'm sorry. All right. Is there a second?
Yes, I second it.
Great. Ms. Marlaud, would you call the roll?
Sure. Armstrong,
No.
Excuse me,
Coulter,
Judge Bashan.
Oh, yes.
May I share that resolution? I think, Mr. Kelly wisely said that a similar resolution, and we have a similar resolution on hand, if you'll
Great.
just bear with me for.
Yes, of course.
So I understood Mr. Kelly's motion to be to adopt a resolution that working group approve in concept, and we can take the commas out of those as we did in the other one.
Yes, please.
Approve in concept the ethical standards for state bar certified mediators as provided in attachment 1 to the August 20th, 2025 staff memorandum for agenda item 2.3. And again, that the standards be circulated for public comment. Thank you for letting me interrupt.
Mr. Kelly says yes. Does the seconder agree to that?
Yes.
All right. Ms. Marlaud, would you please call the roll?
yes. Armstrong,
No.
Coulter,
Yes.
Curtis,
Yes.
Dinkin,
Yes.
Dubois,
Yes.
Ellis,
No.
Dr. Getz, Higuchi,
No.
Higuchi. Thank you. Hodgson, Jones,
No.
Kelly,
Yes.
Kopaken, Cruz,
No.
Lowe,
No.
Judge Lucky,
Yes.
Palevsky,
I abstain.
Robertson,
Yes.
Tuckman,
Yes.
Welch,
Yes.
Yamshawn,
No.
and Judge Pichon.
Yes.
11 yeses and 7 noes, so the motion carries, and 1 abstain.
Thank you, Ms. Marlowe. Ms. Curtis, I'm going to come back to you with kudos for you and your work, your subgroup, because you truly deserve lots. But we're going to come back to that just for the sake of time. So we're going to move on now to our second item, which was the arbitrator subgroup. Sorry, I'm looking for my own notes. Yes, this will be an update and report on the recommendation for baseline certification and recertification requirements for arbitrators. And we'll go to the lead, Judge Jackson Lucky.
Thank you, Chair. And I'm regretfully, I have a hard stop at 5 when we're supposed to finish. So if we haven't called the question by 5, I will have to check out. But first, I want to thank my group and staff. We have had robust discussions, many disagreements, and have found a way to work peacefully together, which I think bespeaks everything we want from neutrals in an arbitration or mediation context. And so in that sense, I think that this group as a whole and my subgroup in particular show what we strive for in this profession. The second thing that I want to do is just emphasize, as Judge Pichon has done, that a yes vote, and in particular, some of my yes votes for this to go out for public comment isn't necessarily an endorsement of the document itself, but that we want this to get out there so that we start getting feedback from a larger constituency than just our group and subgroup. And with that in mind, Alan, if you could please put up our handy dandy chart.
Yes, and I am trying to do that. Having
Sorry, I
little
didn't
trouble
put
with
you on
that
the
again.
spot.
If you have some more introductory materials, I will continue to quickly as I can.
Well, I'll say that Alan, despite his current technical difficulties, Alan and Mia have done a tremendous job in supporting us, giving us some points and counterpoints, giving us things to think about, and I appreciate them so much for that as well. How'd I do, Alan? We got
Thank you very much, but you didn't use up enough time, Judge Lucky, for
all
me.
right. I could tell folks about my really cool underdesk treadmill.
Yes. Can you model it as you did for the subgroup?
Oh, do a little walking on it? Absolutely. So this is without a motor. So you don't need to turn it on or off. It's just powered by your feet. Okay, here we go. Thank you so much, Alan. So one of the things that I want to point out, Dr. Getz had brought up some issues that we might have with the distinction between lawyers and non-lawyers. And then Dr. Getz followed up with a suggestion that maybe we have as a dividing line folks with JDs or degrees or certificates in conflict resolution. And we really did our best to figure out what can we do to ensure that we're giving access to folks outside the bar, but also giving consumers some assurance that someone who has not taken the bar exam or gone through law school has some training or experience in these areas. And so we weren't able to come up with consensus in our group for a universal standard that would apply to both, but we did our best to capture the spirit of the concerns that people had during our last meeting. And so what we can see is our first row is without admission to practice a JD or conflict resolution degree or certificate. And we did talk about that there are people with JDs who do not become members of the bar, who can be excellent arbitrators. So we wanted to make sure that we were clear about this applies to members of the state bar, some of whom are very well qualified and have never received a JD in the state of California, and some who have received a JD but chose not to sit for the bar. And so we have the 24 hours of basic arbitrator training, and then the 24 hours of basic arbitrator training within the 2 years prior to applying for certification. And at least 2 of those hours need to cover ethics standards for neutral arbitrators. And then if the training had taken place some time ago, at least 8 hours of continuing advanced arbitration training within the 2 years prior, again, with at least 2 hours covering judicial ethics standard. And you'll see that that is essentially the same as the standard for practitioners or those with JDs or conflict resolution degrees or certificates. And then we have in the second column at least 3 qualifying arbitrations within the 2 years applying for certification. Our definition of qualifying arbitration is including a contested hearing with at least 2 hours of live testimony and resulting in a written reasoned award. And we included interim, partial, or final awards. And I think that deserves a little bit of background because we felt, and there wasn't a universal feeling on this, but we were able to reach this consensus that as a consumer, you want to know that someone has engaged in making decisions about the credibility of witnesses and resolving conflicts, not just arbitration on paper. There's nothing wrong with arbitration on paper, but we thought that the spirit of consumer protection was that somebody understood that this is a person who sat in a quasi-judicial capacity, made calls on the credibility of witnesses, and then issued a reasoned decision. We chose to include interim or partial final awards because many times as an arbitrator, you've sat through the evidence, you've issued an interim or partial final award, and then the parties decide to resolve the dispute on their own and settle rather than go forward with the rest of the arbitration proceeding. And so in that sense, again, you've engaged in the exercise of applying the facts to the law, etc., and people have seen your work, so to speak. You've shown your work on paper. So we felt that that was the proper definition for a qualifying arbitration. And then while we're here, so instead of forcing Alan to flip back and forth, you can see that the 24 hours of basic arbitrator training has 14 topics, and we had a subgroup who volunteered extra time to work on these along with staff. So again, lots of thanks to those folks who took the extra time to do this on a fairly short timeline, do some research, and figure out what was being offered and what was accessible. Something else that we want to say about the 24 hours of basic arbitrator training is one of the concerns of the members of the subgroup was, are there programs available? And we've talked about that in the past at low or no cost. And it's still a concern of the subgroup whether whether training that will be accessible to people without great means is going to be there. And so there is a sentiment that I've heard from the group in general and from some people in our subgroup that, well, if you build it, they will come, or if you require it, somebody will create the class. And we're optimistic about that, but I'm going to say that we're not 100% convinced that that's going to happen. And then you can see that we have the 8 hours of basic arbitrator training topics. And if we could scroll down a little bit there, again, we've done our best to include topics without being too prescriptive, but covering the things that we think would be important for people to know about their arbitrator, that their arbitrator had received training in the meaningful areas for a neutral arbitrator. And then you can see that we have our definitions of JD, graduate degree in conflict resolution, and then the conflict resolution certificate. So, and these are unsurprising, state bar accredited, regionally or nationally accredited institution, and for conflict resolution certificate having 12 semester units. All right, before we get too far, and what I'd like to do with everybody's permission, since it's 5:40, is get through the document and then we'll open it up. With admission to the state bar, JD or conflict resolution degree or certificate, we kept the number of qualifying arbitrations the same. And the reason I want to start with that is there was some discussion as to whether it should or should not be different, but we really wanted to honor the sentiment that we had heard from the group in general last time about not creating artificial distinctions between members of the state bar and others. And so in terms of the experiential requirement, we kept it the same, but we did say that if you have these other, if you have this other background that gives the consumer some confidence that you understand the mechanics and the ethics of being an arbitrator, that 8 hours of basic arbitration training and at any time, and then an additional 8 hours of continuing or advanced arbitration training within the 2 years prior to applying for certification. And again, the 2 hours covering the ethics standards. Which brings us to our experienced practitioner, again, we voted as a group and had the idea that very experienced practitioners would not have the same training requirements necessarily. And so we have 8 hours of continuing or advanced arbitration training in the 2 years prior, and then at least 2 of those hours being for judicial ethics standards. And you can see that basically what we're doing is for each tier adding one training requirement. Here we had a big jump in qualifying arbitrations, and one might ask why only 3 if for the less experienced person and this whopping 12 for an experienced practitioner. And again, we had robust discussion about this, but I think the consensus that we reached, if I can speak for the group, is that when you're dispensing with the training requirements for the most part, we wanted to make sure that someone who was certified showed that they had significant experience in the arbitration field before we would allow them to forego the training requirements for certification. And then for renewal, we have at least 4 hours of continuing or advanced arbitration training per year, including at least 1 year covering ethics standards. So you can see that we're taking what is necessary for the 2-year prior in initial certification and cutting that in half and saying in 1 year, you have basically half of what would be required for the initial certification. And we have the 3 qualifying arbitrations within the 2 years prior. And for recertification, one of the reasons that we went back to the 3 qualifying arbitrations as opposed to a larger number is that we wanted to make sure that people who were well qualified but had low volume practices, either because they've been doing it a long time and they only want to do a few every so often, or because the nature of their work was bigger, longer arbitrations that were more time consuming, that we had avenues available for those folks to come in. Fairly pleased that I got through that in 14 minutes. So we've left about half the time available for questions or comments. Before I take those, I just want to check in first with members of my subgroup. Anything that I missed that you think bears highlighting, folks?
Great job, Judge Lucky.
Okay, thank you. And then also as to staff, I want to make sure that I give Alan and Mia a chance to chime in on anything that I should have covered but failed to cover.
Great job, Judge Lucky. I just want to say, as pointed out in the memo, staff is neither supporting or opposing the subgroup's recommendation at this time. Staff felt there should be more training for the first category and more qualifying arbitrations for the second category. We think some of these issues may be addressed when the working group looks at tiers, and otherwise we may be submitting comments on it.
Thank you so much. All right, then let's head to questions. We managed that pretty well, 5:45. I'm sorry, the computer says 5:45. It's actually 4:45 my time. And I see Katie's hand up first.
Thanks so much, Judge Lucky, and thanks for this great presentation and all the work that the arbitration subgroup has put in. I did just want to give everybody some context on numbers to be considerate of as we're looking at the number of qualifying arbitrations. In accordance with the most recent OIA report, the Kaiser annual update that they put out about Kaiser arbitrations, 5% of arbitrations submitted went through to definitive hearing. So for context, for somebody to get 3 qualifying arbitrations within 2 years, that means they have to get 60 arbitrations total, at least, assuming 5% of them go to hearing, or 30 a year, which, you mentioned a low volume practice for somebody kind of sunsetting. I don't know if I would consider that a low volume practice. So just to be cognizant of that, perhaps there's a way to expand the definition of qualifying arbitration to include like some motion work, hearing on an MSJ, a motion to dismiss, anything involving oral argument, just because I think it's a little bit challenging or unrealistic to expect folks to get that many arbitration assignments.
I feel you on that. It's something that we discussed quite a bit in terms of the number, and I'm hoping that public comment will give us a better idea as to what's out there. I think that for better or worse, when we select a group of arbitrators like this, they usually have robust practices, and so I think that that's something that we discussed. We came up with the best number that we could, and we're eager to see what other arbitrators say or members of the public say in public comment so that we can refine that number even better. Thank you. Ron.
Thanks, Judge.
Thank you very much. Just for context, for the past 10 years, I've been conducting 20-hour arbitration trainings for about half a dozen bar associations. And just in the first day, all day, we cover the skills necessary before you even have an evidentiary hearing, like not just the ethical requirements, but the skills needed to arbitrate preliminary hearings, handle summary judgment motions, motions to exclude evidence, proper parties, motions for consolidation and joinder, jurisdictional challenges, scheduling conflicts, discovery disputes, and how to draft rulings and orders covering all of these. That's a long day, and that's just to cover stuff before you even have what most people think of as the arbitration hearing. I want to respectfully suggest that if lawyers, those with certificates, have had 24 hours of arbitration skills training, then they will have satisfied that 24-hour requirement. And I want to respectfully suggest that the skills taught in most law schools of being a good advocate are really different than being a competent neutral. So I want to suggest that the working group consider the consolidation of those two and have the same requirement of 24 hours, whatever your background is. Thank you.
Thank you. And then Diana has her hand up.
Hey, just wanted to call attention to the public comment, asking a question about whether if you're a Massachusetts attorney who graduated from Yale, right? Who passed the Massachusetts bar, if you're going to, which column you're going to fall in. So it might be helpful to clarify in-state versus out-of-state things. And Judge Lucky, when you spoke, you had mentioned a degree from a California law school. And I think if the person graduated from Yale, even though they're in New Haven, maybe they should get the same treatment. So just wanted to call attention to that public comment. And I know yeah. So anywhere from anywhere, is that right?
Yes, yes. If I said California, I misspoke. I meant to say California bar member or a Juris Doctor at any nationally, regionally, or state bar accredited institution. So if I misspoke, I apologize. And Diana, thank you so much for calling out the error.
Okay, really fast too. Just wanted to note that I heard some negative feedback from a group with respect to thinking that these requirements were too onerous, and I do have concerns. Not only Katie's point of kind of the numbers, and I ran them on my spreadsheet, Judge Lucky, so over 300 arbitrations. And I've got about an 8% final award on that. And so, we are requiring quite a few arbitrations based on the qualifying number. And then last but not least, Ron, if I give you the technology, can we put your class online and make it available? I'll support you.
We'll talk about that.
All right, it'll be a personal favor to the state bar. The other concern that was raised by a lot of arbitrators was the lack of online available training. And one suggestion that one of them made was clarifying that it doesn't have to be consecutive training necessarily. So, and I don't know if that was our intent, Judge Lucky, because I can't remember whether we ever specifically talked about that. But if you can get 2 hours here, 2 hours there within 2 years, that qualifies, right? Just maybe clarifying it doesn't have to be consecutive, even though consecutive is great too.
I would say you're absolutely right, Diana. I don't think that anybody in the subgroup anticipated or meant to say that these had to be contiguous hours or a semester course or something like that, but just the qualifying number of hours. Obviously, a university or semester or law school course would satisfy that, but it's an hour here or 2 hours there. Is absolutely fine as to my understanding of our group's recommendation.
And last but not least, I'm in super support of us voting on this before 5 to get it out to the public and to hear their thoughts too.
Excellent. Dr. Getz.
Lucky again, your subgroup did a great job. I really appreciate it. I had a suggestion that might address some of the comments. And Alan, if you could scroll back up to the chart. There we go. I noticed that there's some concern about the amount of numbers, that we can generate in arbitrations resolving. And you could eliminate that concern, or at least lessen it, if we took out the number of years prior to applying for certification, because that's really going to be a real limitation so if it's not within the 2 years prior to applying for certification, then even whatever the numbers are, and Diana I think suggested 8%, might get to finality. That wouldn't be as big a concern. So I just wanted to make that suggestion.
I think that's a great suggestion. I see Diana put into the chat that she thinks it's a great suggestion as well. Any other comments? Then, Chair, what I would suggest, if somebody is willing to make a motion that we accept this document for circulation, for public comment, striking the language that Dr. Getz just suggested, maybe we might be able to reach, I think, what everybody is hoping, and that's to get a document out for public circulation and comment or at least get that approved by the end of this meeting.
Yes.
So
And
moved.
With the resolution added in too, so we don't have to vote twice.
Yes.
so who made the motion?
Daniel Yamshon.
Thank you.
You're welcome.
And is there a second?
I'll second it.
Is that Ms. Cruz?
Yes, ma'am.
Thank you. And
Oh,
Mr.
wait, Mr. Plesky has his hand up. Cool.
Yeah, I'm fine with the concept. I think it's a great solution, except as it relates to the recertification, because that would make it superfluous, because you would have already done those 3 in order to get certified the first time.
All right. Well, thank you for that comment, Mr. Plesky. And I'm going to ask Mr. Wiener, were you able to type that into a resolution? The motion?
You'll give me just one moment.
Sure.
I will bring that up. I'm just having a little bit of trouble with my screen sharing, but let me.
While Alan's doing that, Cliff's point is a decent one, right? Like the math's not math and on the recertification. But Katie's point still stands of, assuming a 5 to 10% rate, that means you've got to have like 30 to 60 arbitrations within 2 years, which is quite a lot still. I don't know. Could we change it to maybe 5 years, Cliff? What do you think? Or like group?
Yeah, I'm okay eliminating the time. I think it's okay to eliminate the time reference. I don't know what it means for the recertification, because
It might be meaningless if we write it like that. Yeah.
If I could also just, for point of clarification. My understanding is that the low percentage, every time I've heard it spoken, it's going to final determination, and just wanting to see whether that's somewhat different from the recommendation, which is, includes interim awards and partial final awards as well. And I'm just wondering whether the 8% and 5% statistics we're hearing accurately represent what the subgroup had recommended.
Let me run it on interims right now. Hold on one sec.
And I would say anecdotally, while we're running that, I don't see that would be a meaningful difference. It might move the needle slightly, but I don't think that it's going to make a big enough difference that the 60 within 2 years is going to be would change as our estimate. And while Katie is researching, Paul DeBow has his hand up. Paul, sir?
Well, I just want to point out, a lot of cases settle because somebody prevails on a motion for summary judgment, or they end rather there. But that's a final decision. But the problem is that when the motion for summary judgment, if it's for the whole case, there's no problem. But quite often it's a partial motion for summary judgment, which nevertheless leads to a settlement. So the partial summary judgment is not a final decision. So that's the problem that, and I think Katie has a point. It may not be 5% in other mediations other than med mal, but still I would say that less than half the cases go all the way to an arbitrator final decision.
And I agree that, again, this is something where we talked quite a bit about it, and I think I don't want to speak for Cliff, and he has his hand up, but one of the concerns, because I advocated candidly for an MSJ should count, and he made the point that from a consumer perspective, that doesn't give me any guarantee that the arbitrator has seen the whites of their eyes and made a credibility determination and made a decision on the merits. And so I think that as a compromise position, we took the interim and partial final awards as a proxy for experience as opposed to MSJs. But again, I share your concern, and I think it's an excellent one. Cliff.
Yeah, I'll be clear. I understand the concern, but I don't want to do anything that encourages motions to dismiss and encouraging summary judgment motions just to hit the number. They are really, really a problem in arbitration. I'm not sure they belong in arbitration for the most part. And I'm afraid that would be the effect of that.
Thank you. And Diana?
We got 1 minute left, so I'm going to renew my motion and call for a vote and ask Eric Tuckman, who's got the most robust database out of all of us, if he can give us some numbers on how many cases go to final award. My number went up to 12%, including interims, but that we can discuss that at another meeting as we kind of hear group feedback.
I don't want to go out of turn here, but just very quickly, in response to the question, in the commercial context, about 40% of the cases that are filed go to an award or partial final award. In the employment context, it's much lower, maybe 15% or 20%.
That's encouraging, though.
Yeah, similarly, our consumer database is around 8 or 9%, not dissimilar to Diana's.
Yeah, consumer would be much lower for us as well.
Mm-hmm. Mm-hmm.
All right. So Diana, I just want to make sure, because we were doing this orally, do the two documents on the screen right now accurately reflect the motion that you're making?
Can we change the 2 years to 5 years on the bottom one? And again, this is just for public comment, but I
Yes.
think even running that, depending on what kind of arbitrator you are, let's give people some wiggle room, but not make it so that you got to have a ton of arbitrations depending on what kind of practice you're in, especially if you get unlucky those 2 years, you know?
I'm sorry, point of order though, the document on the left of my screen talks about mediators, not arbitrators.
That's a good point, Ron. So we just need to edit that.
Yes, can I just speak to the 5 years? The reason for the 2 years, I mean, there's the issue about the certification. So how are you going to reconcile, completing the arbitration within 5 years if you have a 1 year or 2 year renewal cycle? I just would question that.
That's a good point too, Alan.
That is a
All
very
right, I think we leave it as is. My motion is we leave it as is, send it out for public comment, and then our working group kind of noodles on how to fix this.
all right. And then who is the seconder?
It was Daniel Yamshawn, I believe.
That's right.
And do you accept the amendments or the change?
I do, yes.
Okay, and Mr. DeBoe's hand's been up for a while.
Oh, I'm sorry. I should have lowered it. I did
Okay.
speak. Thank you, Judge.
All
Excuse
right.
me.
I'm sorry, I need to apologize. This resolution is not,
You're just in the wrong document. You go to close that one and go to 2.2.
oh, I go to 2.2. Thank you.
I think we should put this vote off till the next meeting. It's after 5 o'clock.
We're very, very close.
Judge Lucky, how hard is the hard stop?
I'm softening it up as we go. I'll just be late. I don't want to delay it. I don't want to delay the group, so I can apologize. I can apologize later to other people.
Yeah, and I don't want to rush anyone. So if the group wants to hold it off, great. I just think that if our resolution is just to send it out for public comment, we can definitely take feedback between now and the next meeting. And that way we're moving the ball forward while we're still massaging the right result.
Absolutely.
Can I observe that the working group, and I can't speak for the mediation working group, of course, had to add extra meetings because we all wanted to thoroughly discuss everything and understand everything. I can only assume the mediation group went through the same kind of process given the quality of the work they produced. So I'm wondering if we're being a little optimistic about how much work we can accomplish in any given meeting. And I know nobody looks forward to a lot more meetings, but we may have to calendar some.
Duly noted.
Ellen, you want to remove the comments? I mean, the comment.
Thank you.
All right. We've had a motion and a second. Is there any objection to us proceeding on? Okay. Ms. Marlaud, would you call the roll?
Armstrong,
Yes.
Coulter,
Yes.
Curtis,
Yes.
Dinkin,
Yes.
Dubow,
Yes.
Dubow. Thank you.
Yes.
Ellis,
Yes.
Dr. Getz, Higuchi, Hodgson, Jones,
Yes.
Kelly,
Abstain.
Kopaken, Cruz,
Yes.
Lowe,
Yes.
Judge Lucky,
Yes.
Palevsky,
Yes, noting that the recertification standard doesn't seem to make a lot of sense, but yes.
okay. Robertson,
Yes.
Tuckman,
Yes.
Welch,
Yes.
Yamshawn,
Yes.
and Judge Pichon.
Yes.
The motion carries.
Thank you. The last thing we have, and I'm coming back to my wonderful people, are the minutes. Has everybody had the opportunity to review them?
Yes.
Yep. Yep.
There are any
Madam
correct?
Chair, I call the question.
All right. May I have a motion to approve?
I so move.
Is there a second?
Second.
Ms. Marlaud, would you please call the roll?
Armstrong,
Yes.
Coulter,
Yes.
Curtis,
Yes.
Dinkin,
Yes.
Dubow,
Yes.
Ellis,
Yes.
Dr. Getz, Higuchi, Hodgson, Jones,
Yes.
Kelly,
Yes.
Kopaken, Cruz,
Yes.
Lowe,
Dane, I had to miss that meeting.
okay, Judge Lucky,
Yes.
Palevsky,
Yes.
Robertson,
Yes.
Tuckman,
Yes.
Welch,
Yes.
Yamshon,
Yes.
and Judge Pichon.
Yes,
The minutes have been adopted.
thank you. All right, before you leave, it is imperative that I tell you all thank you. I know we're in the middle, we're still in the middle of all this, but first of all, let me say thank you to the leads. Ms. Curtis, wonderful leadership. I appreciate all the time you've taken. It's just been wonderful work with the product that you've produced. Thank you so much.
Well, thanks to my subgroup. Thank you,
And
Judge.
to your subgroup, the members of your subgroup. I know how hard it's been. I know how much effort you've put into this. I know how many meetings you've had, and you've put out a wonderful product. And as I said before, please understand it is out for comment, and we will discuss every single comment that comes in. And Judge Lucky, thank you so much for staying with us. I know you have so many things to do like everyone else, but thank you so much for staying to the end. Thank you for your leadership, for your hard work, your vision, and also thank you to your subgroup. I know where you started at the beginning. You've come a very long way, and that means that you have an open mind and you have considered all of the comments that have come into you. Um, we still have a lot of work to do, but this is a good showing for our groups. And I've already told Dr. Getz, thank you for his work with his group and his subcommittee. They presented early on and resolved early on, and everyone was able to accept it early on. So I am going to be a bit autocratic at this point, and that means that the subgroups are now discharged, and we will form new subgroups, and we'll let you know what they are and who's on them very shortly. So thank you. Thank you so much. I realize you've worked very, very hard. Thank you. So it looks like we are done for the day, and you'll be hearing from us very soon about the new subgroups and membership on them. But thank you.
Thank you, everyone.
Thank you, Judge Pichon.
Thank you, Judge Pichon, for your leadership.
Thank you. It's been a pleasure. Bye, everyone.
Bye.